All right, Mr. Hassel, if you can unmute, please.
Yes, Your Honor.
All right, thank you. We're on the record in Hassel versus Bergman. This is case number 1716873. The record should reflect both parties are connected by Zoom. Ms. Kraus, can you give me an update on where we're at with this file today?
Yes, this hearing was adjourned from August 5th after the plaintiff motion for support was supposed to be heard in front of referee Kyle Legal on August 28th. The motion was dismissed due to non-appearance of all parties. Friend of the court previously had contact with the plaintiff requesting the weekly job search. Friend of the court did not have any communication or contact from the plaintiff until August 27th. He did by email to the supervisor, Edward Brzezinski, which included job searches. We've additionally received job searches from Friday after business hours and then also on Monday. His support obligation is $883 and the balance is $21,891.06.
All right. Mr. Hassel, have you had any luck with those job searches?
I'm still waiting. I had a couple calls, but they are way out of I couldn't make it. They were like hour and a half away. So they on Indeed, but I've applied to probably over 60, 70 different jobs, and I'm just waiting for them to call with the holiday weekend. I assume they're not doing too much calling. But I have received 2 of them. They were just too far away for my ability. So I'm still pursuing and trying. I've applied to a lot of factories and wherever is in my area.
Okay, so the court's going to reset this for another hearing in 30 days. Mr. Hassel, it's important that you continue with the job searches and that you provide those to Ms. Kraus or the friend of the court, I'm sorry. And we'll see where we're at that point in 30 days. If you haven't been able to get a job at that point, we'll have to look at some potential other options moving forward. But the most important thing is that you demonstrate to the friend of the court that you're actively seeking employment over the next 30 days, okay?
Yes, Your Honor.
All right, okay. That's all for today. Both parties on that file are free to disconnect at this time. Okay, we've got somebody on the phone. The last 4 digits are 5406. Can you tell me your name, please, and unmute? Ma'am, on the fire tablet, can you tell me your name, please?
Superwriter. I'm up on the phone. I wasn't sure if it was connected.
Okay, I'm sorry, you broke up there. Can you tell me your last name again?
Writer.
And what case are you calling in on? I don't see that name on our docket.
Ken Gregory. 9 a.m.
Correct. Okay. All right. And are you Tracy Gregory then?
I'm Tracy Forrider.
Okay. Formerly Gregory?
Correct.
Okay. Great. Thank you.
You're welcome.
And you were connected on the phone as well, you said?
No, I disconnected from the phone.
Okay. All right. So this is Gregory versus Gregory, case number 029557, or Forrider versus Gregory. I'm sorry. I We have Ms. Forrider connected. I do not see Mr. Gregory connected. Ms. Kraus, can you tell me the status of this file?
Yes, a bench warrant issued on January 18th of this year for the defendant's failure to appear for a show cause hearing. On August 15th, the defendant posted the $1,600 bond. This is an arrears only case with a balance of $3,719.22. Friend of the court would request the bond to be released to the friend of the court and be applied to the defendant's balance. The defendant has reported a new employer and his start date was today. An income withholding has been sent to collect towards his arrears and the remaining balance. In front of the court would request the show cause to be dismissed due to the defendant indicating he will self-pay until monies are withheld from his check.
All right, thank you. Ms. Forrider, was there anything that you wanted to say regarding this matter?
Nope, I think he's finally getting this taken care of.
All right, so the court will order, as Ms. Kraus has indicated, that the bond that's been posted be released to the account and dispersed. And then the court will dismiss the show cause based on the information provided by Ms. Kraus. Ms. Forrider, did you have any questions?
I do not. I appreciate it very much.
Okay, thank you. You're free to disconnect at this time.
Okay, thank you.
Okay, if I could have the gentleman on the iPhone, if you can unmute yourself. Can you tell me your name, sir?
Stephen Allmacher.
Mr. Allmacher, okay. I'm gonna put you back in the waiting room. I've got a couple brief matters to address and then your case will be next, okay?
All right, sounds good.
Thank you. All right, and Ms. Hornstra, if you can unmute yourself, please. Thank you. Are you Abigail Hornstra?
I am.
Okay, we're on the record in Hornstra versus Foost. This is case number 2218992. Record should reflect Ms. Hornstra is present today by Zoom video. I do not see Mr. Foost present in the Zoom courtroom. Ms. Kraus, can you tell me the status of this file, please?
On May 21st, the defendant was arraigned before your honor, where the defendant was to be released to work camp to serve 15 remaining days from his sentencing order and appear in front of the referee, Kyle Legal, on July 17th. He failed to appear, and per Officer Keller from work camp reported that he did not report there upon release. The defendant's support obligation is $178 and the balance on the account is $5,019.80.
Okay, based on Mr. Foost's failure to appear here today, as well as his failure to report to work camp, the court will request that the friend of the court prepare a bench warrant for his arrest. And we'll proceed further once Mr. Foost is arrested and brought before the court. Ms. Hornstra, did you have any questions at all?
No, but Mr. Fust is in the Kalkaska County Jail right now.
Okay. All right. So Ms. Kraus, once that bench warrant is prepared and signed by the court, can you reach out to the Kalkaska Jail and to set up an arraignment for him?
Yeah, I can do that.
Okay. And I'm actually going to be in Kalkaska tomorrow. I don't know how fast we can, do all of this, but if we can get that arranged so that he's not released from Kalkaska before we can get him on the record.
All right, I'll do my best to get the forms to you to sign as quickly as possible.
Okay, thank you. Ms. Hornstra, anything further that you wanted to address today?
I just am trying to figure out if I have to be at the next court date. I am almost ready to go into labor, so.
Yeah, any hearings that you would need to be present at, we would send you a notice. And if you've got something like that, obviously, if you let the friend of the court office know, then we can make arrangements to reschedule it or excuse you from the hearing.
Okay.
But in terms of his arraignment, you know, that next hearing, if we can get that set up, that is not something that you would need to be present at anyway.
Okay, yeah, he's supposed to get out, I think the 5th, his mom said.
Okay. Okay, very good, thank you. You're free to disconnect at this time.
All right, thank you.
Hello?
All right, Mr. Butts, are you able to hear me?
Yes, sir. I can see you now.
Okay. So we're on the record now. This is two files. Glazier versus Butts, case number 1415211, and Dalvinspec versus Butts, case number 2218954. Ms. Kraus, can you tell me the status of these two files today?
On the case with Glazier, as of 8/26, this is an arrears only case due to the child residing with the defendant. Friend of the court would ask that the defendant make reasonable payments monthly towards the arrears balance and request an order on arrears in the amount of $150. The balance on this case is $22,869.68.
Okay, Ms. Glazier, was there anything that you wanted to say regarding your file today?
No, sir. I'm super glad that William is having a relationship with Maya. She's striving with him. She's excited to start school and live with her dad after, you know, many, many years of not having him available. So I'm very proud of both of them. So nope, I'm good.
Thank you.
All right, Mr. Butts, can you continue to make payments towards the arrears on that
Yeah,
case?
Yes, sir. I got to come in today and make a payment, and I also got to get a work change because I start mech in Vanderbilt on Friday. So I got to get a change of work paper right there from the lady at the front desk, and then I'm gonna come in and put a payment for Miss Glazier and for Miss Dobbins.
Thank you.
Okay, so Ms. Kraus, in terms of the case with Ms. Glazier, the court will adopt your recommendation as the order going forward. And then on Ms. Dalvinspec's case, Ms. Kraus, can you tell me what your recommendation is on that one today?
The current monthly obligation for that case is $395. The balance remaining for that case as of today is $7,652.62. It does appear that the income withholding that has been sending payments is not collecting the requested amount. So we would actually request to adjourn out to November 4th in front of your honor to monitor income withholding payments. If those payments are met, we would remove the hearing. But if he has a new employer, we would request that he makes payments self-pay until that order is in effect, the income withholding.
Okay, so the court's gonna adopt that recommendation, and Mr. Butts, you just need to do basically what you said already here, which is continue to make the payments and then provide friend of the court with that new employer information as soon as possible.
Yes, sir.
Okay. All right, thank you. That's all on those two files. All parties on those cases are free to disconnect at this time.
Thank you.
I don't know how to disconnect.
Hang up, buddy.
Okay. Next case is Fritz versus Galt. This is case number 1013413. This was set for 9 a.m. It's now 9:20. None of the parties on that file have appeared today. Ms. Kraus, how does the friend of the court want to proceed on that file?
Is the court aware if the defendant is still incarcerated? He was as of Friday, but I didn't check the inmate list this morning. I'm checking right now. It does appear he's still listed in jail.
Okay, so we just need to get the jail to connect with him.
Yes, and honestly, we were going to request to adjourn this hearing out to November 4th to address contempt finding second. And hopefully maybe the other pending charges could be addressed before then. So I don't know if it's necessary for him to appear or not. That's up to you, but that's would be the friend of the court's recommendation.
All right, since we're gonna adjourn out and since he's incarcerated, which would limit the court's ability to proceed today anyway, then I agree with your recommendation. Let's move that out to November 4th. And then we'll provide Mr. Galt with the paperwork reflecting that there at the jail.
Thank you.
1 second here. I need to take a phone call. Okay, we're back on the record. The next case is Smoker Moore versus Schoolcraft, case number 1917839. Again, the record should reflect that neither of the parties on that file has appeared here today. Ms. Kraus, how did you want to proceed on that file?
A bench warrant issued on June 12th for the defendant's failure to appear for a show cause hearing and was arrested and posted the $600 bond on July 20th. The defendant has a support obligation of $68 and a balance of $858. The last payment was received in January of this year in the amount of $100. Friend of the court would ask that the bond be released so it can be applied towards the defendant's support obligation and arrears balance. Friend of the court is not seeking contempt at this time, but would request to set the matter in front of referee Kyle Legal on October 16th at 9 a.m. to possibly screen for contempt if needed.
Okay, based on the information you provided here, I agree with that recommendation. The court will adopt that, order that that bond be released to the account, and then order that that hearing occur as you indicated. All right, and then let's see, we have Ms. Frank. All right, Ms. Brink, are you able to hear me okay?
Yes, sir.
Okay, we're on the record in Brink versus Hildebrandt, case number 11145050. The record should reflect Ms. Brink is present today by Zoom video. Ms. Kraus, can you tell me the status of this file today?
This hearing was adjourned from August 5th to allow the plaintiff to obtain friend of the court forms regarding disability and complete and submit them back before today's hearing. No information has been received regarding her inability to work. The only contact the office has had with the plaintiff is on August 12th, when she dropped off a letter requesting to sign off her rights to the child and support to stop. Friend of the court staff did indicate she may need to reach out to probate court to move forward regarding that information. And outside of that, the plaintiff has a support obligation of $197 and a balance of $8,709.16. The last payment was received in February in the amount of $206.47 from a prior income withholding.
Okay, Ms. Brink, why did you not submit those forms as you were ordered to at the last hearing?
I never received them.
Okay. Did
They
you
were
go in
supposed to have been mailed to me.
Did you go in to get the forms?
They were supposed to have been mailed to me. That's why I provided my address at the last court hearing.
Okay, did you do anything to follow up with that at all?
I mean, it's not really my responsibility when someone doesn't do their job.
Well, it's your responsibility to pay your child support payments, and if you don't
But
pay
that
those
has nothing to do with the disability paperwork.
okay, I'm not gonna argue with you. We went
I'm
through
not
this
arguing.
yeah, you are, and we went through this at the last hearing. We confirmed your address. We told
Right,
you
so that they could be mailed to me, which they were not.
they were mailed
And I
to
would
you.
like to sign off my rights to my children. And Devin said that he would not fight it. Bill did not fight it. He came and he signed. And when it came time for Devin to sign, he didn't show up. And I have a text message saying that he doesn't want, or that he wouldn't fight me on signing off my rights to Lila or John. So I'm not sure why he didn't sign the paperwork.
So you still are the parent and you still owe the child support.
But I'm requesting the court to terminate my rights to my children. She has a stepmom that can adopt her. I don't want anything to do with her anymore.
Well, there's a process for that, and that process hasn't occurred yet, which means
okay, well, I've asked for that process to be started a year ago. This is the second time I'm bringing it up.
Okay, well, you have to do more than just ask. It's up to you to
well, that's why I had the document written up and by an attorney, and so that Devin would sign the paperwork, and he said he wouldn't fight me, and then he didn't show up to sign it. So I don't understand what the big problem is.
Okay, so how are we going to deal with you paying your child support till that happens then?
I don't know. I have a paycheck coming from Boyne River, and you can have that. Okay. But other than that, I have $34 to my name. My house is for sale, and I'm living in my car.
When are you getting that paycheck?
I don't know. It should be garnished. I probably won't even get a paycheck. It should be garnished by child support.
Do we have an income withholding, Ms. Kraus, for any employers with Ms. Brink?
There is a potential income withholding, but it wasn't reported. So outside of her indicating where she's employed today, that process could take 6 to 8 weeks. So I can't guarantee that monies would be withheld from that paycheck.
Yeah, it should be. I've never had a problem with it not being withheld in the past.
Okay, well, we don't have the information from your employer, right? Ms. Kraus, is that what you're saying?
Yes, you do. Oh, they reported it.
Hold on, Ms. Brink. Ms. Kraus?
An income withholding was sent, but until monies are withheld, we wouldn't be able to indicate if that amount would be withheld. But the employer was not reported. It's pending, so I can't guarantee that the employer received anything.
They did. Okay. They told me.
Well, we haven't received any money from them, so apparently they haven't.
I haven't gotten the check yet. I haven't even been, I get paid every 2 weeks. And I've already lost the job. They already fired me.
So you're not employed. You're not employed is what you're saying.
Not currently, no. I lost the job. I got fired. The bartender didn't like me.
Okay. What about the disability? Where are you at with that?
I filled out all the forms that they requested from me and mailed them back in the timeline that they gave me. But I'm living in my car, so I don't have access to my mailbox anymore. So I have to contact disability today after I get off the phone or after I get out of court and report my address to be at my parents' house. Now there's no guarantee that I'm going to get my mail. My parents don't like me. So there's no guarantee that they're going to tell me that the disability paperwork comes. I'm going to have to, I don't know what I'm going to do because I don't have gas to get to their house. And they have me blocked on the telephone.
Your Honor.
Okay. Yeah, go ahead, Ms. Kraus.
In regards to her being homeless, she may be able to reach out to the local post office. They may have something for her in regards to obtaining a PO box, but she would need to check further into that.
Well, I don't have money to pay for a PO box.
They may have some options for you regarding if you're homeless right now. I don't know the details in regards to that, but it is some information that friend of the court has received in regarding post offices when people are homeless.
Okay, I'll look into that.
All right, well, here's Ms. Kraus, has there been, how many findings of contempt has there been in this case on Ms. Brink?
This would be a first finding.
Okay. All right, so Ms. Brink,
I'm not in contempt, Your Honor. I have no problem paying it. It's just I can't get a job because I have felonies. No one wants to hire me.
I do
I've already put
consider
out more applications. I'm not in contempt, though. I have no problem paying. It's just that I can't get a job. No one wants to
Okay.
hire me.
you are in contempt, first of all. I find specifically that you are in contempt because you aren't doing any of the things that I ordered you to do the last time, and you can't just
Your
say,
Honor,
well,
like what?
like fill out the forms for your disability.
They
Communicate
weren't
with-
mailed to me. How can I
You
fill out
just-
forms that weren't mailed to me?
I'm not going to
I
argue
called
about.
and asked. I
Okay,
called and asked.
Now I'm finding you in contempt for continuing to interrupt me during this court hearing and inhibiting the court's ability to conduct this hearing. You're continuing to talk over me. I'm trying to explain to you.
I asked you a question.
You just told me that you're not getting mail at your parents and there's no guarantee that you're going to get your mail. So how do you know that you didn't get this? We sent it to the address that you gave us.
And I was living there up until Friday.
It's not my problem that you aren't getting your mail. All we
I
can do
am
is send.
getting my mail.
Obviously,
It's
you're
not making
not.
sense, Your Honor.
All we can do is send it to you at the address that you give us.
And you
then
didn't.
It's up to you. So you haven't followed through with what you were required to do.
Yes, I did. I called the child support office and asked about it, and they said it was too soon for me to be calling.
And you now so that I can say what I need to say for the record here, because you're continuing to talk over me and I'm not able to conduct this hearing. So the court adjourned the previous hearing in August to give you an opportunity to submit the forms that were required to be submitted. That's your responsibility to make sure that that's done. We had this colloquy the last time about your address. You gave us an address. That's the address we've been using. If you haven't received the mail, that's between you and the post office and you and whatever is going on with the address that you gave us. All we can do is send out forms. If you didn't get them in the mail, then it was your responsibility to contact the friend of the court, go to the friend of the court, make arrangements to get those forms and fill them out. But that's squarely your responsibility. It's your responsibility to pay child support for your child. That's still your child. Your parental rights haven't been terminated. As far as I can tell, you haven't done anything other than say you want that to happen to make that happen. So you haven't paid child support. You haven't complied with any efforts of the friend of the court to give you options outside of paying child support. So the court finds that you are in contempt because this would be a first finding of contempt. The court finds that you should be sentenced to 45 days in the Otsego County Jail. The court is going to order that you turn yourself in to the Otsego County Jail by 5 p.m. today. That's September 3rd, 2024, to begin serving the 45-day sentence. If you fail to turn yourself in to the Otsego County Jail by 5 p.m. today, then the court will issue a bench warrant for your arrest. Ms. Kraus, if you can prepare an order to reflect the ruling of the court on that today.
Yes.
All right, that's all for this hearing today. The court's going to disconnect from this brink at this time. All right, Ms. Kraus, that's all I have left for front of the court docket. Was there any other cases that I missed from your standpoint?
No, there's just a couple, I think, that you're hearing just for regular motions.
Okay, very good. Thank you.
Thank you. All right. We're on the record now in Allmacher versus Allmacher. This is case number 2419629. We have both parties connected by Zoom video here today. Ms. Allmacher, are you able to hear me okay?
Yes.
And Mr. Allmacher, are you able to hear me okay?
Yes.
So this is set for a status conference here today. I see from the file that the parties, it looks like reached agreement in terms of custody and parenting time. Minor children in here. Ms. Allmacher, in terms of dividing up any assets or debts of the marriage, have you been, from your standpoint, have you and Mr. Allmacher been able to reach agreements as to those types of things?
Yes.
Okay. And Mr. Allmacher, do you agree with that?
Yes, I do.
So at this point, it looks like we would be able to proceed with a final hearing to finalize the divorce. There's one final form that I would need you to fill out and submit to the court. Typically, Ms. Allmacher, the filing party or the plaintiff would do that.
Okay.
And that's a form that you can get online, or it may have been if you downloaded or got a packet of forms to file for divorce, it's probably in that packet as well. But again, it's a form called a judgment of divorce. So I would need that to be filled out and submitted to the court, along with any final orders from front of the court. And then the court will take testimony from both of you and we can finalize the divorce, and I can set that for a final hearing today.
Okay.
Do you have any questions about that final form, Ms. Allmacher?
No, I don't. I already have it. We just need to finish filling it out and submit it.
Okay, very good. Mr. Allmacher, do you have any questions at all?
No, I do not.
Okay, so the court will set that hearing for about 30 days. It'll be by Zoom, just like we're doing today. As long as we have that document submitted ahead of time, it'll only take a few minutes to take the testimony I need to take, and then we can finalize things. The court will send you both a notice of the date and time of that hearing, just like you got for today's hearing. Ms. Allmacher, do you have any other questions?
I do not.
Mr. Allmacher, do you?
No, I do not.
Okay. All right. Thank you. That's all for today. And you're both free to disconnect at this time.
Okay. Thank you.
mute on start video.
Okay, Mr. Roll, are you able to hear me okay?
Yes, I am. Good morning, Your Honor. Can you hear me?
Morning, yes, thank you. Sir, are you Matthew Strabbing?
Yes.
Okay. And Ms. Brink, we're going to need you to go into your Zoom app and connect your audio.
My screen shows she's doing that now, Judge.
All right, Ms. Brink, and then all right, Ms. Brink, are you able to hear me okay?
Yes, sorry about that.
Okay, we're on the record in Brink versus Strabbing. This is case number 2419690. This is a hearing to enter a final judgment of affiliation as well as a child support order. And Mr. Rolla is present on behalf of people in the state of Michigan in this case. Mr. Rolla, is there anything that you wanted to state for the record here?
Well, Judge, the court should have the copy of the signed consent judgment of affiliation by the parties. I think the court's still going to need to take some brief testimony from at least one of the two of them before an order can be entered. Thank you.
All right, Ms. Brink, you are the mother of Axel Robert Brink, is that correct?
Yes.
Okay. And you understand that if the court enters this order today, it would establish Mr. Strabbing as the father of Axel. You understand that?
Yes.
Okay. And then this order would also provide that you and Mr. Strabbing would share joint legal custody of Axel, and that you would have physical custody with parenting time as agreed for Mr. Strabbing. And as the mother of Axel, is it your view that entering this order would be in your child's best interest?
I do.
Okay. And Mr. Strabbing, you understand that, again, the court entering this order would establish you legally as the father of Axel. You understand that?
Yes, Your Honor.
Okay. And also with the, it would also enter those orders with regard to custody, parenting time, and support. We understand that as well.
Yes, Your Honor.
Are you contesting that in any way?
No, sir.
Okay. All right. The court finds it would be appropriate to enter those orders today. If either of you would like copies, Mr. Rolla, can they get those from your office?
Our office will be providing them with copies. Yes, Your Honor. Thank you.
All right. Thank you. Ms. Brink, did you have any questions at all?
Not at this time, Your Honor.
Okay. Mr. Strabbing, did you have any questions?
Ms. Brink and I have discussed possibly an agreement where lowering child support would be an option just based off of our proximity and, you know, the hurdles that, you know, the first thing that we discussed was, do I want to have a role in relationship with Axel? And I do. But because there's a 3-hour distance in between us drive wise, we find that's a little bit challenging, so to just gap that hurdle, we talked about maybe possibly lowering the child support versus what a typical, formula looks like.
Yeah, so that's something that one or both of you should contact the friend of the court office to discuss that with them, and they can help you with the procedure if you want to agree to that with changing the order and getting it modified.
Okay.
Okay, thank you. Mr. Rolla, anything further from your side today?
No, Your Honor. Thank you.
Okay, thank you. That's all for today. All parties on this file are free to disconnect at this time.
Thank you.
Thank you.
Next hearing set for 10 o'clock. We'll take a short recess until that time.
All right. Thank you, Your Honor.
Okay, ma'am, is your name Ashley Link?
Yes.
Okay. 1 second, please. All right, we're ready to go on the record. This is Ashley Link versus Tyler Watson. This is case number 2419769, and this is set today for entry of an order of affiliation. We have Ms. Link present here today by Zoom video. Mr. Rolla is here on behalf of the state of Michigan. This hearing was set for 10 a.m. It's now shortly after 10. I do not see Mr. Watson joining in the hearing today, although he was provided with notice of the date and time of this hearing. Mr. Rolla, anything that you wanted to state for the record in support of entry of these orders here today?
Yes, I do, Your Honor. The court's well aware some time ago, both yourself and Judge Hunter asked us, my office, to prepare a legal memorandum on issues that we're going to be addressing momentarily, specifically where the court has a signed consent judgment and or a signed order of acknowledgement of paternity or affidavit of parentage, even when it gets to this hearing where you have the respondent given proper notice of the hearing and he doesn't respond, the court has sufficient information to enter an order after taking some testimony from the mother in this particular case that the entry of the order would be in the child's best interest. We would ask the court to do so in accordance with that legal memorandum previously provided to the court.
All right, thank you. Ms. Link, I have a few questions for you. First of all, you are the mother of, is it Elias? Is that how you pronounce it? Okay.
Yes.
Of Elias Link, you're the mother, is that correct?
Yes.
All right, and you understand that by the court entering this order here today, that is going to legally establish Mr. Watson as the father of Elias. Do you understand that?
Yes.
Okay. And then this order would also provide that you would have sole physical custody of Elias and that you would have joint legal custody with Mr. Watson. And then this order would also provide for payment of child support by Mr. Watson to you to support Elias. Do you understand all of those things?
Yes.
And as the mother of Elias, do you agree that entering these orders would be in your child's best interest?
Yes.
Do you have any objection to the court finding legally that Mr. Watson is the father?
No.
All right, so based on the status of the files indicated by Mr. Rolla, based on the statements of Ms. Link here for the record, the court finds it would be appropriate to enter those orders. The court will sign those. Ms. Link, did you have any questions at all?
No.
Okay. Mr. Rolla, is there anything else that we need to address for the record here today?
Just advising Ms. Link that our office, after we receive the orders back from the court, will be able to provide her with a copy thereof.
All right. Thank you.
Okay, thank you. That's all for this hearing today. All parties on this case are free to disconnect at this time.
Thank you, Your Honor.
Thank you.
Court's next hearing is set for 11:30, so the court will be in recess until that time.